Perfect.
So good evening, everyone. Welcome to the panel discussion about From Watergate to Biden, 43 years of international anti-corruption efforts since the birth of the Fcpa, organized by the Washington Foreign Law Society. I'm Juliana Canet, the president of the Washington Foreign Law Society, founded in 1952 to promote knowledge and understanding of international legal matters, comparative legal studies, and foreign law. This evening is the first of a series that we will host over the next few months on this issue, on trend and issue of international anti-corruption. I hope you can join us also for the next couple of seminars. Given the number of participants, you will be muted, but you will be able to interact with us through the Q&A section. Thank you for those who already sent your question. We'll try to get to those at the end of the seminar. Please start sending questions whenever you have the chance, so we can, from time to time, look at the Q&A section. Today, the session will be recorded and you will find it soon after the seminar in our website. Let me introduce the guest speaker today, very distinguished panel, very active professional, Pascal Dubois. She's an international executive advisor and independent expert, and who has been involved in anti-corruption for more than 2 decades. She recently retired, believe it or not, from the World Bank. I thought she just joined the bank, where she was the VP for integrity and leading also the World Bank efforts, investigative efforts and pursuit of sanctions in connection with allegation of fraud and corruption in finance projects by the World Bank, in addition to corporate compliance and prevention. Pascal has also worked and served as a first chief suspension and debarment officer at the World Bank. She's a member of the Washington Foreign Law Society. Welcome.
Thank you.
Lucinda Law, she's a partner at Steptoe. Her practice includes representing audit committees, board of directors, and company in internal government and international financial institution audits, investigation and enforcement matters involving fraud, bribery, corruption, and other compliance issues. She served as the firm management committee and heads of compliance, investigation, trade enforcement department. She also leads Steptoe Brazil specific initiative incorporating a focus on Fcpa, anti-corruption compliance and enforcement work. So you saw already from the background that today will be a truly international discussion, a truly comparative. You will go in 1 hour around the world. So let me start with the first question to both of you. We heard and read more and more often about international corruption, international anti-corruption efforts in the newspaper, and more than the local ones. So there is a sense that maybe foreign transnational bribery rather than the domestic bribery are now in the rise. What is your taking on that? Is a new phenomenon? Is something that comes from far? Pascal?
Thank you, Juliana. Thank you very much for having us this evening. As I told you, when I first moved to Washington, D.C., the Washington Foreign Law Society was actually the first organization that I joined. And so I'm very happy to now be on the board and be able to help with everything that the organization does. So I'm also very happy to be with Lucinda. And Lucinda, I remember first time that I heard of you was when I had first joined the Integrity Vice Presidency. I'm talking now, in 2004. And you were the president of the ABA Anti-Corruption Task Force. It was not even called a committee in those days. It was a task force. So, I think that really shows how much has been done, right? When I think about these very early days. And so when we go to the title of tonight's panel discussion, From Watergate to Biden, 43 years of international anti-corruption efforts since the birth of the FCPA. So the Washington Foreign Law Society looks at foreign laws and at the interaction between, you know, all these different laws around the world. And I think there is no law better suited, in my opinion, than the FCPA, and to observe as foreign lawyers, as international lawyers, the impact that that one law has had. You've all read the invitation, and so it was described how when there was the Watergate scandal in America, it came to light that there were slush funds that had paid illegal campaign financing. And at the same time, it was discovered by the investigators, and especially the SEC investigators, that these slush funds had also been used, slush funds from US multinational companies, and that these slush funds had also been used to pay foreign government officials. And so the SEC head Stanley Sporkin, and there was a program actually done by the Washington Foreign Law Society in June, commemorating the work of Stanley Sporkin. I listened to it again today. Great program, good to put on your viewing list. And so Stanley Sporkin was watching the televised renditions of the hearings, and he thought, no, that's interesting. These companies are paying these foreign government officials. I wonder how they put this on the books. And so, long story short, that gave rise to the Foreign Corrupt Practices Act, which has two components. It has the anti-bribery provisions, which are implemented by the Department of Justice. And so that's the prohibition to pay a bribe to a foreign government official, because when one speaks about international anti-corruption, one speaks about the prohibition of paying a bribe to a foreign government official. It was always illegal to pay a bribe to a local government official. So we're not talking about the laws or, you know, applicable in America or in Italy or in Belgium, where it's illegal to pay by an American to pay a bribe to an American government official, by a Belgian to a Belgian government official, Italian to an Italian government official. What we're talking about here is somebody in one country and the prohibition to pay a bribe to a foreign government official. The FCPA also contained, and that was actually the first focus, was accounting provisions, books and records provisions. So all issuers must have books and records, have accurate books and records, and then also internal controls provisions. So what happened was that the moment that the US had a law like this on the books, the US companies, industry were like, well, you know, if we can't pay a bribe, how about the Belgians and the Italians? I'm always going to say Belgians and Italians because Juliana is Italian and I'm Belgian. And so it was, in terms of, you know, leveling the playing field, obviously was not a very good idea just to have one country. Fast forward, the US starts looking for a convention that would ensure that its then major trading partners would also be covered by this FCPA, and that was the beginning of the OECD Convention, which is came about in '97. And around that same time, World Bank was also very much under the influence of, or pushed by the US, also started working on fighting corruption. The moment that the OECD countries, so at that time, the major trading partners were covered by the OECD Convention, and were forced now to also have FCPA-like laws on their books. The moment that that was done, the OECD countries then said, well, why don't we make sure that the rest of the world is covered? And in comes, and that was, I'm looking at my notes here, I'll get, make sure I get the date right, the UN Convention Against Corruption, which came about in 2005. And there then, one really sees a very interesting phenomenon, right? Because you have a national law from the 70s, the FCPA, which then becomes one international convention, OECD convention, another convention which is a UN convention, which now covers, every single country in the world. And then those conventions then push all these other countries to put in place FCPA-like laws. And so, for instance, now you have in France, you have Fcpa Is, and you have UK Bribery Act, and all over the world, there are FCPA type laws. And so it's a national law, becomes an international convention, pushes all the international financial organizations, multilateral development banks, to have corruption. It looks like we lost Juliana, and it says I'm the host now. I hope she's coming back. I see, I guess the other participants are still there. I'll continue. So, what we then see is that the rest of the world has really been catching up. Lucinda, before we go on to the next question.
I'll just tell a story that I've never been sure whether it's apocryphal or not, but since you attributed the OECD convention to U.S. efforts, I'm going to tell it because people who were in the U.S. government at the time say it was really the Germans that brought us the the OECD convention and actually German companies, and the story they tell. And again, it may be apocryphal, but the story they tell is that German industry went to the German government and said, these bribes are getting really expensive. They used to be 5%, then they went to 10%. In some cases, they're going to 15%. The US companies have a defense. They can say they'll go to jail if they pay. We want a defense too. And suddenly the alignment changed because actually the US Congress and the FCPA was passed in 1977 and became effective the following year. In 1988, the US Congress, as part of a trade act, said to the executive branch, go out and negotiate international standards. And guess what? They got nowhere. There was no appetite at that point for taking this up on the international agenda. So it took another 10 years effectively till we got to the OECD convention, and the world changed in that period of time. And it's a really interesting discussion as to why the world changed that we can get into in the Q&A if people are interested. But it took other countries coming on board and agreeing that this was an area where we needed greater harmonization, because until then, for almost 25 years, the FCPA was the only transnational bribery statute in the world, and inherently extraterritorial, if you want to think of it that way, with all the issues that creates. But you're quite right. Today it's a very different landscape. We'll talk later, I'm sure, about the enforcement issues and what that has meant. But it's an area where there has been such rapid change at the international level and such rapid acceptance of international standards that it's really interesting. And it's also a really interesting area because of the relationship to national law. And the international standards are a kind of floor. The philosophy of the OECD convention is something called functional equivalence. That a country like France or like the UK or like Brazil, and it's open to non-OECD members, by the way, and there are a number of them, can adopt legislation that fits within its own national system. And it has to fit within its own national system because that's where the enforcement takes place. It doesn't take place in the International Court of Justice. There's no International Anti-Corruption Court. There is the World Bank and the IFIs. We'll talk about them later, but this is national enforcement, so that's really where the implementation and enforcement take place. The OECD has to sign up to the convention, and the OECD is really the one much more than the UN convention that's made a difference in transnational bribery, for foreign bribery, because that's really its sole focus. as opposed to the UN convention that is much, much broader. So to sign up for the OECD Anti-Bribery Convention, you have to join something called the Working Group on Bribery, which is a peer review process. The US gets reviewed, every country gets reviewed, and they look at, is there implementation? Is there enforcement? And they go into great depth, actually, in the national laws and enforcement regimes of the country. You can see on their website, if you're interested, these very detailed reports that talk about how the systems work. So it's a fascinating area for the relationship between national law, foreign law, if you will, and international law. So those are my initial comments, Pascal.
Yes.
Your very good recitation of how this all came about.
Maybe we can start looking at a little bit of practical example that can be very interesting for our audience. Maybe Lucinda can go on a little bit on the challenges that companies or private sector face in all these jurisdictions, although now there are more peer-reviewed and looked up, but what are the challenges that nowadays they face compared to maybe 10 years ago, from your point of view?
Sure, and let me say first, thank you for organizing this. I've been a member of this organization for many years as well, and enjoyed the Sporkin event last June, and see many people I know participating today. So thank you for joining. So this is an area that from a practical point of view, really presents many challenges. There is no statute that I know that affects such a wide range of business conduct as the FCPA. It's not just a question of public contracts and government procurement. FCPA issues can arise in all your third-party relationships with partners, consultants, representatives. It can arise in any touch point a company has with government. So it can come up in every regulatory area. It can come up in tax. It can come up when you move goods and people across borders with customs, immigration, those kinds of authorities. It can come up when you make charitable contributions in a foreign country. It can come up when you deal with security issues. And the list goes, it can come up with mundane things, and some of these things really implicate not just the laws of other countries, but also cultural practices, social patterns, political and economic issues. It's one thing that makes the area very, very interesting. But even, practices, business courtesies like gifts, entertainment, sponsorships, hosting people and travel, all those kinds of business practices can raise FCPA issues for companies that are subject to these laws. And one of the great transformations the FCPA has worked, and it's not just in the US, it's also internationally, is that companies, and in the US, of course, we have corporate criminal liability, as well as civil liability for issuers, as Pascal mentioned, under the securities laws. The FCPA is part of the federal securities laws in the United States. That was Judge Sporkin's genius. But so there are parts that apply to SEC registered companies, and there are other parts that apply to other persons, individuals, and companies. But for companies, there have really grown up expectations that they will take steps through compliance programs to manage risks, to prevent, detect, and remediate problems. And one of the greatest challenges for a multinational company is to develop and maintain, Juliana, an effective program, a compliance program that's properly designed in terms of the specific risks that the company has, where it does business, how it does business, with whom it does business, the extent to which it uses third parties. All of those things need to be taken into account in the compliance program. And compliance standards, we have seen tremendous evolution since I started doing this some years back. It's not just a question of adopting a policy that says we don't bribe. You know, it's figuring out where you need to have controls, adopting those rules, teaching people what they are, monitoring what they do, enforcing them if they're violations. That sounds simple, but it's really challenging to do when you think about a multinational company with operations all over the world. How do you get people to buy into that? Particularly, how do you get people to buy in when they may be under great pressures, from various government officials or others in the countries where they're doing business? Maybe everybody else pays bribes and you're trying to say no. When there are family practices, cultural practices that come into play, things that people have grown up with in terms of how they do things, how do you change that mindset? So designing, implementing, and making effective a compliance program is a very challenging thing that requires a lot of resources to do right, and constant attention and improvement and learning from experience. So and yet it's something that's expected. In the US, we don't have a defense to criminal liability or civil liability, for that matter, for these compliance programs, although they will mitigate your liability and penalties if you have a problem. In some other countries like the UK, under their new anti-bribery legislation, there's effectively corporate liability, but a defense if the company has what are called adequate procedures, which is really a compliance program. So the compliance idea has taken root, starting in the US, but it's really grown internationally. And actually, we've seen tremendous convergence around what those standards should be. And now you have many national laws, these Fcpa equivalents that Pascal talked about, some of which really build in defenses for compliance programs or at least mitigation. So that's an area where we have seen just tremendous change. And we'll talk later about job opportunities, but let me just say at this stage that the whole compliance industry, I have a number of people who've worked with me over the years who are now playing compliance roles. It's been a huge growth area, and more is a separate part of a company from the legal function. Sometimes they're merged, sometimes not. So that's one of the biggest changes I would say I've seen. There are more I could talk about, but why don't I pause there, because I know you have more questions and Pascal may want to comment.
Thank you so much. This is fascinating. So Pascal, from your point of view, World Bank, IFIs, how these changes take effect? What is the role of IFIs in all this?
Sure.
Can you tell a little bit more?
So it was very interesting. When I went to law school, which is by now, 35 years ago, anti-corruption was definitely, or international anti-corruption was definitely not on the menu, right? So this was not something that one was taught. But by the time I joined the World Bank, which was in '97, the year before, Jim Wolfenson, who was the then president, who recently passed away, and the papers were all over, a lot of newspapers mentioned his achievements. And one of the things that he was particularly proud about, Jim Wolfenson, was the fact that he started anti-corruption at the World Bank before his famous annual meeting speech in '96. Corruption was referred to literally as the C word. There was actually at one point, there was I've seen that report. There is a report called the C word. And so if you're looking at anti-corruption at the level of international financial institutions, obviously one needs to look at what they're in the business of doing. And so an IFI, an international organization such as the World Bank, and also the regional multilateral development banks. They're in the business of lending for development purposes. And so over the years, a system was built whereby if a contract, a government contract that is financed by the World Bank. So the way that the World Bank works is that, let's use an example, Kenya. World Bank will lend, say, 200 million to Kenya, and then to build roads. And then the Kenyan Treasury will use that money to enter into literally thousands of contracts to actually build those roads. And it's those government contracts that are financed by the World Bank. And so according to the loan agreements of the World Bank, if there is any fraud, corruption, collusion, coercion, or obstructive practices in those government contracts financed by the World Bank does have jurisdiction to investigate and then to sanction those companies. And the sanction is a debarment. And there then, it's important to point out, differences between FCPA type laws and what you see at the level of international organizations. So in FCPA, as we know, we were just discussing it, it goes after the payment of bribes, and it ensures that there are correct books and records. At the World Bank, one talks about fraud, not only about corruption, but also about fraud, collusion, coercion, and obstructive practices. So that's a big change. And then also the FCPA is a criminal law. The sanctions are you can go to jail, or there's very large penalties. And I was reading the other day that as far as the FCPA is concerned, this year is actually a record year. There's never been higher penalties, not just for the FCPA, but also for FCPA-like laws around the world, which is very interesting to note. But back to the World Bank and the other multilateral development banks, the sanction there is a debarment, and so that means in Europe it would be called an exclusion. So it means a number of years, a period of time that a company will no longer be able to receive new contracts financed by the World Bank. And it's very interesting that Lucinda was mentioning, the compliance program. So to the extent that the FCPA is an American export, the compliance programs, which are now absolutely normal, right, for any company in its right mind to have, also has been, in my view, very much an American export, because for all these companies that knew that they might be at the receiving end of US prosecution, they've learned over the years that it was essential to have a compliance program in place. The US does not give a defense, such as one can see in the UK Bribery Act with the adequate procedures. It also does not oblige a company to have a compliance program, such as is the case in France. Companies with a certain certain number of employees, I think it's 500, need to have a compliance program in place. But you see that these days, most companies doing around the world, at least, companies doing business around the world that are well advised, will have compliance programs in place. And this is something, Lucinda, you would agree that over the past 10 years even, right? I mean, over the past 20 years, but especially over the past 10 years, it's become such a big business, and there used to be like a handful of people working in this field, and now it is just huge. In the course that I teach at Georgetown, I tell people, you're always going to be able to find a job in this field. And literally several of my former students actually are in this field right now, and it feels very good, and we're still in touch. It's very nice to see that they are happy and doing work in this field. There's actually several participants on this Zoom webinar that were former students. It's nice to see their names.
Well, if I could go
Sure.
ahead, Julian.
Go
I'd
ahead.
love to comment on this. So I will say, first of all, that Pascal, I've represented for many years, basically since the beginning of the bank's sanctions program, companies, contractors, consultants that are caught up in these audits and investigation and sanctions proceedings. So it's a great pleasure to be on the same side of the table as Pascal, rather than on the opposite side of the table. We can now talk about things we didn't used to be able to talk about things, but you know, you can't underestimate what a huge pivot this was for the international financial institutions, really led by the World Bank. And there was a legal opinion from a general counsel of the World Bank that said no, that the bank couldn't pay attention to these issues, that it was an interference with the sovereignty of its member states to look into bribery and corruption issues. Now the philosophy has changed. It's really a question of making sure the bank funds are being used for the intended purpose. And so it's accountability for assets. It's more of a trusteeship context. And for those of you who are interested in international law, this is a world where a whole system has grown up over the last roughly 25 years since the rules started to change, and the bank has developed a whole sanction system with an external, now all external sanctions board. It has a settlement system. It has these norms that have been harmonized with other international financial institutions. There's a cross-debarment agreement that greatly magnifies the effect of a debarment sanction. And for the companies I represent in this space, who are often very dependent on these types of public contracts, a World Bank sanction can literally be a death sentence to the company, much more serious than having to pay a monetary fine if they are in a business where are dependent on public contracts, because the multiplier effect these days, the collateral consequences, even though the bank, I'll get in my little dig here, refuses to consider them, they are huge. They are very, very significant and growing. And so it's an important part of the picture. US policy is to cooperate with the World Bank. Every US settlement contains language that requires companies entering into a deferred prosecution agreement, for example, or with ongoing cooperation obligations post-settlement, to cooperate with not only with the US, but with the World Bank and other.
Which is very interesting. Huh? Yeah. And it shows again, I think, the influence that the US has had over the work of the international financial institutions, and also the continued influence that the US has over the other countries. I had the opportunity to attend several of the meetings of the working group on bribery of the OECD, because the World Bank had the observer status, and you really see how you know, the US, I think, deserves a lot of credit, because without them, I don't think this would have gone anywhere. Also, it's because of the US continued pushing of what happens in international organizations that this whole field is actually, you know, continued. And I think, you know, right now we can say that it's a thing that is going to stay. Juliana, I'm looking at the list of things that, you know, we were going to discuss. So maybe now it might be a good time to look at the levels of enforcement and what gaps there still are. Because what we
yes,
yeah, go ahead, go to you, over to you, Juliana.
Sure. And also, maybe for my background or for the audience that I see, another good part or path to take is to see new trends, like we saw how the system is in place, the compliance, the effect on the company. But what about intersection with investor-state dispute resolution, commercial arbitration, all these new kind of intertwine of two fields and how they play a role? Maybe you can have a little bit on that, and then we go to enforcement.
Sure. Well, so I can take a stab at that, Juliana, and I'll start because you asked the question about how it's bleeding over into other areas, and it is. I mean, it's not just the exclusion issues, debarment issues in procurement and international projects that Pascal has talked about with the World Bank and others. But these issues are also increasingly making themselves felt in civil disputes. And in international arbitration, you have, of course, commercial arbitration and investor-state disputes. And in fact, you see these issues of corruption becoming very common now in both aspects of international arbitration. In the investor-state context, it has become a defense that is being raised by the respondent states with increasing frequency. And occasionally it also gets raised by a claimant as part of an affirmative claim, for example, that corruption figured into their unfair or inequitable treatment. I think that's the most common way it comes up, but on the claimant side, but really where you see it more is on the defense side, where the respondent state is saying that the investor engaged in corruption in the course of the making of the investment, or sometimes the performance of the investment. And this can raise at the outset jurisdictional issues. Many bilateral investment treaties, for example, have legality clauses that require that the investment be made in accordance with law. And going back to what Pascal said at the beginning, every country of the world has anti-bribery laws that are at least domestically focused anti-bribery laws. And so if it can be established that an investor engaged in corruption usually at the making of the investment, that's usually how these legality clauses are written, then that could mean that the tribunal will consider that it has no jurisdiction to hear the dispute. Even if the investor has performed, the host countries receive benefits, the case may be dismissed for a lack of jurisdiction. And we've seen some prominent examples of that in the investor state arena in recent years. My favorite case, and a lot of people's favorite case, because the facts are remarkable, is a case that arose out of Kenya called World Duty Free versus Kenya. It involved a concession to a foreign investor to own and operate some duty-free stores primarily in airports throughout Kenya. And there actually wasn't a corruption defense there raised, but in the course of pleading the case, the principal shareholder of the foreign investor submitted an affidavit in which he admitted to delivering a suitcase full of money. I mean, this is just the classic bribe scenario, a suitcase full of money to the then president of Kenya in order to secure the concessions. And so there you had an admission in writing from the investor that he said, oh, no, that was Harambe. That was just a customary payment. That wasn't really a bribe. But the tribunal said, well, we have really no choice. We can't hear this case. And it was dismissed on jurisdictional grounds. Now, often, of course, the questions of proof are much, much more difficult. And we've even seen cases where the arbitral tribunal has taken matters into their own hands to a certain extent to try to ferret out what's going on. A leading case of that in that vein is a case called Metal Tech versus Uzbekistan, which was an Oecd case of a few years back with a tribunal chaired by Gabriel Kaufman-Kohler, which had seen some disturbing indicators in the course of the proceedings that there may have been bribes paid. This was an Indian investor trying to get a concession in Uzbekistan and hired a series of consultants. One was a sitting government official, another was a brother to a very senior government official. And the tribunal took it upon itself to sort of ask questions, follow the evidence, take some inferences, and ultimately concluded that the investment had been procured by corruption and dismissed it for jurisdiction. So these are just a couple examples of some cases where the corruption issue has led to very consequential results for these investor state claims. The issues coming up all the time in commercial arbitration as well. And there are many, I could spend hours on this. It's a topic I'm quite interested in and have worked in. So I won't spend hours on it because we don't have hours, but I'm happy to answer some questions. But there's just a lot of open issues when you try to merge the arbitral world with these compliance issues, whether it's corruption, money laundering, or even now business and human rights really coming into the fore. So let me stop there, but happy to take questions on it later on.
Thank you, Pascal.
Hi, yeah, so it's very interesting to watch, right, what is happening in the area of arbitration, because it really is a sign of the times that also in that area, corruption and anti-corruption has become an important factor, and that there is an acknowledgement that corruption is extremely bad for societies, and that it's not a victimless crime, that there are consequences when bribes are being paid. One thing that I wanted to add in terms of where we are right now, so by now worldwide it's clear that anti-corruption is something that is, like I said, is going to stay. It's something that has received a lot of attention and acceptance, right? Which is also what you can see when you're looking at arbitral awards. At the same time, there is a lot of difference in terms of enforcement between not only the OECD countries themselves, and as Lucinda was mentioning, OECD Convention is the one that is the most, the best implemented, thanks to the fantastic work that is done by the working group on bribery and the secretariat of OECD Convention. But between the countries, there is a lot of difference. And then there is also a lot of difference between the OECD countries and the non-OECD countries. And so I'm picking up on a question that I saw had come in from Marcia Wiss. When it comes to leveling the playing field, if not all countries do have the same level of enforcement, I would agree that it does remain more difficult, both for companies and for the government that actually are implementing a high level of enforcement. And I was looking at the 4 countries that have had an active enforcement in the recent past. There's the US, the UK, Switzerland, and Israel. But that's 4 countries with active enforcement, and you're looking at 15 countries with limited enforcement and 19 countries with little or no enforcement. So it's even though we can say that anti-corruption is a thing that is here to stay, at the same time, this is not a time to rest on our laurels and to think that actually things have improved. One other thing that I want to mention there is that it's become a bit of a fashionable topic which is good and bad. And good in the sense that, yes, more people are accepting it. And you see this, for instance, in the number of people that want to join this field. There's also a lot of cynicism yet that can be caused by certain countries or certain organizations jumping on the bandwagon and saying, you know, rah, rah, you know, we're going to fight corruption, when in fact there is a big discrepancy between what is being said, right, and what is in fact being done. And so that can lead to cynicism from, you know, the level of populations or, you know, employees of companies. And so I think, you know, one needs to take with a grain of salt some of the fantastic statements that are being said.
Thank you. Yeah.
I think, for instance,
can I add more grains of salt?
Yes, I'm thinking, for instance, you know, I saw what is it, like, you know, the leaders declaration of the G20, right? You know, I mean, once in a while you get these, you know, very, you know, nice sounding statements, and it's good that they're there. But at the same time, I think sometimes it breeds a certain level of criticism when there is like I said, a discrepancy between what is said that is going to be done and what is in fact done in practice. Yeah.
Absolutely, and that's one of the challenges in this area. I was just going to say, picking up on Marcia's question and stepping back a couple of steps. So Pascal, you mentioned earlier that at the time the OECD Convention was put into force, it represented the great bulk of world trade, and that really preceded the rise of China. China is an observer at the OECD working group on bribery. It is not a member. It has a foreign bribery law. I don't think it's ever enforced, to my knowledge.
That I recently read that it has never been enforced.
So I don't think it's ever been enforced. China has cracked down on domestic corruption. I know we've got some questions about domestic corruption in the US that we'll try to address during the course of this, but it's cracked down very much on domestic corruption because that is perceived as affecting its political legitimacy within China. But the overseas posture is still very different. Now, I will say, I don't know what your perception is, Pascal, but you've seen just a raft of cases involving Chinese companies out of the World Bank. In the last few years, there are many Chinese companies doing international infrastructure projects in connection with the Belt and Road Initiative who've run afoul of the World Bank rules. So you see enforcement in that arena quite a bit in the last few years, and we're now starting to work with Chinese clients to develop compliance systems and you know, we have one state enterprise client that's been designated a pioneer to really do this right, and so we'll see how it all evolves. But that there are obviously major gaps in the system. Just to talk about supply side, and I want to underscore that the OECD Convention only deals with the supply side of the bribery equation. It deals with the person who offers or pays or authorizes an improper payment. It does not deal with the public official who demands or solicits or receives a payment. That's really left to the host countries to deal with, and it's another huge gap in the system we could talk about. So I just wanted to do those kind of framing points. Yeah.
No, very interesting. Actually, we received some question on the enforcement, and so looking at the perspective in a way, if you can comment on both the local and international side, what is the potential impact of the new administration, Biden? How do you see cases evolving? Both internationally, do you see an enforcement getting stronger? We have a question on the chat about local example on Texas and how to deal with this kind of behavior, and what do you think about this? So if you can comment on a perspective point of view, if you can guess, we are in a critical moment. How do you see the enforcement going forward? Thank you.
Maybe I can start with that. So I've been finding this very interesting that the enforcement levels in the US, because I mean, going to the question about Biden and the incoming administration, the enforcement in the US has actually stayed very high. Now, there is always a lag time between cases started and cases being finished, right? So you can only really see the numbers or the results a couple of years down. But when you listen to the FCPA unit prosecutors, it certainly looks like the enforcement levels have remained. Lucinda, would you, and one other thing that I wanted to say, as what I've always observed is that in the US, whether it's Democrats or Republicans who are in charge, maybe for different reasons, but they've always been very much in favor of the FCPA. No, the current president at one point said it was a very bad law, but the administration, the other people in the administration, you know, seem to continue to promote it and pushing this, you know, level playing field. And what I've noticed is that, for instance, under the Bush years, FCPA was being pushed for national security reasons. And then I remember Obama speaking about international anti-corruption, linking it to poverty levels, which would be more you know, in line with what the World Bank, and the reason why the World Bank is interested in fighting corruption. Lucinda, what is your view on that? Are you expecting, as a long-term practitioner, a big difference?
So I'm going to address this in two parts, if I may. One is domestic US enforcement, talking about the FCPA. The state of Texas is its own republic and raises many issues. And there are organizations like the Coalition for Integrity that have looked a lot at what the different states are doing. And if you're interested, you may want to look at some of that work. There's actually some shocking gaps in the ethics rules of different states of the United States. But enforcement in the United States, one misconception, especially abroad, is that enforcement is political. Mm-hmm. It is not very political. There are some differences in justifications and approaches and priorities that different administrations bring, but enforcement is done by career prosecutors at the Department of Justice and the SEC. Yes, they are influenced to some extent by higher up, but not so much in their enforcement policies or day-to-day actions. And so changes in administration mean less than many people, especially people overseas, tend to think. And that's number one. So I do expect perhaps some changes. You know, the many of the cases that you alluded to, Pascal, at the beginning, have been cases that have been in the pipeline for some time, and I don't think the pipeline is quite as robust as it has been. Some of that's because of the pandemic. It's very hard to investigate these things in a pandemic situation when you can't be on the ground and talk to witnesses and really understand what's going on face to face. It may be that we're going to see a little bit of a pipeline issue over the next year. But one thing we need to appreciate is that the US is not driving this bus anymore by itself. It was for many years, but it is not these days. One of the main things that even though we have this sporadic and not universal enforcement in countries that have FCPA-like laws, it's actually very hard to enforce it. It requires a lot of expertise and a lot of resources. But one of the things the international standards have done, besides universalize the FCPA, is that the treaties that we've talked about have facilitated cooperation internationally in investigations and enforcement. And so now we're living in a multi-jurisdictional world. We have cases, think of the recent Airbus case, for instance. That was a concurrent settlement of the US, the United Kingdom, and France. The first really big case that France did, and they got the lion's share of the penalties. That was concurrent, so the three authorities cooperated. They all have jurisdiction over this, but they took different pieces depending on their interests. The Goldman case, the largest FCPA fine that's ever been assessed, which came down just a few weeks ago, followed on from enforcement in Malaysia. You should look at the list of cooperating countries in that case. It is astonishing how many countries rendered assistance. And so we're in a new world of cooperation. It isn't always easy, it isn't always smooth, but it's changed the landscape. The Brazilian prosecutors, I know some of you are interested in Latin America. The Lava Jato prosecutors are on WhatsApp with their counterparts at the DOJ. They're talking all the time. And so this changes the enforcement landscape. So we are now in a multi-jurisdictional world. Sometimes it's concurrent investigations of different authorities. Sometimes it's sequential, sometimes it's both. But it means that the dynamic around these issues is quite different than it used to be. A number of FCPA cases, virtually all of the Brazilian cases in recent years are not cases that started in the US. They started someplace else, and then the US got involved. So that's the new reality that we're dealing with today. At the same time, we're trying to get countries that should be enforcing to be enforcing more. But those, there are a lot of countries that are engaged in different ways, and they're not always showing up in the enforcement statistics.
Yeah, one thing that I will find a big advantage with the new administration, and I think everybody working in this area is saying the same thing, is that it's going to be easier to sell again, because a lot of anti-corruption practitioners have told me that they thought it was rather difficult to sell the concept of anti-corruption. And that especially, I mean, I'm Belgian, I can get away with it, but even if you're American, it was a lot more difficult. And that you got, a lot of rolling of the eyes when you were sitting in front of foreign audiences. So at least from a very practical point of view, they should make it easier. And another thing that I want to mention, which I think is interesting, is that, so you saw for the longest time that it was really the US only that was enforcing the FCPA and was waiting for all the other countries, especially OECD countries, to have enforcement itself. And as Lucinda pointed out, we've seen unprecedented cooperation with the Airbus Lava Jato case, and others. Now, it's going to be interesting to watch what is going to happen in, say, the next 5 to 10 years, because it's always been, the US going mostly after foreign companies. What's going to happen, for instance, if other countries start going after US companies? This is going to happen, or are all US companies, do they have such fantastic compliance programs that it's not going to happen to them? I mean, I think it's going to be really interesting to watch this continue, not only the cooperation, but also individual enforcement, and what some countries are going to do. Countries tend to like to look at what companies from other neighboring countries are doing. So for instance, the UK, when they started enforcing, they didn't go immediately after UK companies, they went after French companies. So, like, stay tuned, I would say, right? So this is a very interesting area, also geopolitically, to see. And then you're talking about, you know, the non-OECD countries, India, China. What's going to happen in that space is going to be interesting to watch.
Thank you so much. Before closing, we were receiving a lot of questions and a lot of good comment, positive comment. Clearly is a fascinating topic, but mostly fascinating speakers. We should have many more of this. If I can allow 30 seconds each, there is clearly an interest for people to enter in this field. You mentioned there is great potential, and mostly you mentioned that you cross path with anti-corruption in a kind of casual way or unconscious way. So if you can give one advice to people that would like to enter in this field, and then we'll conclude the evening.
Lucinda, you first.
Oh, in 30 seconds? Oh,
yes.
Oh, Juliana, this is difficult. Well, this is an area that's easy to be passionate about, and I think you maybe can tell from our remarks that we're both passionate about it, and so I think it's a great area to practice. And we've mentioned the growing opportunities in compliance, but there are also opportunities in enforcement, in private practice, international organizations. For people who like being in the world, you have to be a bit of an explorer, and having some languages can be very helpful as well. So I think for people who like the complexity of the world, it's actually a very interesting area, and you can, within it, there's multiple sub areas you can focus on. You could be more on the preventive side or more on the investigative and enforcement side. There's policy work, so there's a wealth of opportunities potentially too if you find this of interest.
Thank you.
I think Lucinda, you said it all. I would absolutely agree. Language skills is very important, right? So, which is why it's a wonderful field for foreigners, for instance, who live in America, because the language skills are so useful. Yeah.
So thank you to both, Pascal, Lucinda. Thank you for all our audience. The recording will be posted, and stay tuned for the next one. Bye.
Ciao.
Ciao.
Thank you.